We are going to discuss today the second installment of Article 48, which is complex crimes proper. Now, what is the legal basis for the existence of the complex crime proper? Again, I would like to refer you to Article 48, which states, and I quote, when a single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed, the same to be applied in its maximum period. Now, the underscored portion of this provision is what is being referred to as the complex crime proper, when an offense is a necessary means for committing the other. Okay? Now, previously, I have discussed what compound crime is. And for purposes of revisiting the same, it is what? It is committed or it happens when a single act constitutes two or more grave or less grave felonies. Now, what are the requisites of the complex crime proper? First requisite, that there be at least two offenses committed. Okay? Similar to the first kind of complex crime, the compound crime, in complex crime proper, there must be at least two offenses committed, because if only one offense is committed or is produced, then you do not talk about of complex crime proper or even of compound crimes. Second requisite, that one offense or some of the offenses is a necessary means for committing the other. Third requisite, that both or all of the offenses must be punished under the same statute. So, for purposes of this slide, I am just giving you a rundown of the requisites of the complex crime proper. We will discuss each of these requisites in detail as we go through the succeeding slides. First requisite, that there be at least two offenses committed. Examples: the complex crime of malversation through falsification of a public document. Malversation is one crime. It is the act of a public officer who, having custody of public funds or property for which he is accountable, misappropriates the same. On the other hand, falsification is another crime. It is the act of fabricating a document or changing the contents thereof or imitating the signature of another. Although at this outset, I would like to make it of note that there are various acts of falsification. The definition that I put here in this slide is only one kind or one act of falsification. There are many acts of falsification under Article 171. Here is another example. The complex crime proper of forcible abduction with rape. Forcible abduction is one crime. It is the taking of a woman against her will and with lewd designs. Rape, of course, is another crime. It is the act of having carnal knowledge of a woman through force, threat, or intimidation. Now, similar to falsification, there are various ways, several ways under Article 266 by which rape can be committed. This is just one of its definitions. Another example, the complex crime proper of estafa through falsification. Estafa is one crime. It is committed by defrauding another person, either with unfaithfulness or abuse of confidence or through deceit or false pretense. And similar to falsification, estafa can be committed in several ways under Article 315 of the Revised Penal Code. Now, we will not go into a detailed discussion of each of these crimes because we are only mentioning these crimes in relation to our discussion of complex crimes proper. Now, I am just giving you these definitions for you to be, or for you to have an idea of what these crimes are. But let's go back to the first requisite. No, the first requisite requires that there must be at least two offenses committed in order for a complex crime proper to exist, just like what is shown by these examples. Second requisite, that one offense or some of the offenses is a necessary means for committing the other. So take note of this second requisite. This is, I think, by far the most important requisite with respect to complex crimes proper. Okay? So, one offense is a necessary means for committing the other. Let us dissect this second requisite for your better understanding. Necessary means should not mean indispensable means. Take note, necessary means does not mean indispensable means. Why? Because if the first crime is an indispensable ingredient of the second crime, then the first crime will be regarded merely as an element of the second. And if it is regarded merely as an element of the second, it becomes part and parcel of that second crime, such that there will be no first crime to speak of. Okay? Example, if X deliberately sought to kill Y by setting fire to the house where Y was sleeping, that is, the use of fire was primarily chosen by X to kill Y, then what could have also been a crime of arson becomes absorbed as a qualifying circumstance in murder. Again, you look closely at the example. What is the intent of X here? The intent of X here is to kill Y. Okay? Only that the way by which he wants to kill Y was by means of fire, or by the use of fire. So, again, if X deliberately sought to kill Y by burning his house where he was sleeping at the time, then what could have been also a crime of arson becomes absorbed already as a qualifying circumstance in murder. Now, if you haven't known this, no, Article 248, which defines and penalizes murder, enumerates the qualifying circumstances there which qualify a killing into one of murder instead of homicide. Okay? And the circumstance of by means of fire is one of these, or is one of those qualifying circumstances, such that if the means used by X or by the offender is by means of fire in killing another person, then the crime is only one crime, that of murder, not two separate crimes, nor a complex crime of murder through arson. Okay? Example number 2. X, a member of the New People's Army, ambushed a military vehicle, killing 8 soldiers. Here, there is no complex crime of rebellion with murder, because the murder committed here by X is already considered as absorbed in rebellion. Okay? We will discuss more of that when we go to the next few slides. How is the crime of rebellion committed? Rebellion is committed by rising publicly and taking up arms against the government for the purpose, among others, of overthrowing that government. Now, in the attempt to overthrow that government, the rebels who compose the rebellion would usually commit or resort to common crimes like murder, arson, robbery, etc. Like, for example, a hit squad of the NPA is ordered to or was ordered to assassinate a local politician who is supportive of the anti-communist insurgency program of the government. The killing of that local politician by the rebel ordinarily would have constituted murder. But since it was perpetrated in furtherance of the rebellion, or it was connected with the rebellion, that rebel will no longer be prosecuted for that common crime because the murder there will be deemed absorbed in the crime of rebellion. Okay? However, a rebel who commits common crimes, not in furtherance of the rebellion, but for some independent or personal motive, he will be separately prosecuted for such crime. It will not be deemed absorbed in the rebellion already. Okay? Please remember that. Let's now go to another topic. That one offense is a necessary means to commit the other. What does this phrase mean? This means, or this phrase means that the first offense is committed to ensure and facilitate the commission of the next offense. Okay? The first offense is merely used to ensure the commission of the second. The ultimate goal of the offender here is to commit the second offense, not the first offense. But he has to use that first offense so that he will be able to reach his goal of committing that second offense. Example, X with lewd designs forcibly abducted Y for the purpose of raping her. Here, the forcible abduction, the first crime, was committed by X to ensure or facilitate the commission of rape, the second crime. Look closely at the example. What is the ultimate criminal resolution of X? His ultimate criminal resolution is to rape Y. But in order to rape Y, he had to forcibly abduct her. Okay? So the forcible abduction here, which is a crime by itself, was merely used to facilitate or ensure the commission of the next offense. These two crimes are totally separate and distinct from each other. Both crimes can exist independently of each other. Okay? Forcible abduction is not even an element of rape because rape by itself can exist even without the forcible abduction and vice versa, for the simple reason that either of the crimes is not an element of the other. So that is what is meant by the phrase, the offense is a necessary means to commit the other. That's why you have this so-called complex crime proper. An offense is merely used or used as a necessary means to commit the other offense. Example number 2. X, a teller of ABC Bank, forged the signature of the bank officer authorized to sign the check and thereafter deposited the check in the account of a fictitious payee. Here, the forging or the falsification of the check by X was merely facilitated by him to ensure the commission of theft. Okay? So, X falsified or forged the signature of his co-employee, making it appear that his co-employee signed the check and thereafter deposited the check in a fictitious account. And he took the value of the check by withdrawing from that fictitious account. So he committed another crime, theft. Or as you will know later when you go to Book 2, it is properly termed as qualified theft. Now, there are two crimes committed here, falsification and theft. But the falsification, the first crime, was merely used to facilitate or ensure the commission of the theft. Okay? Because without the falsification, X would not have succeeded in stealing the amount of the check. Okay? This is another example of the complex crime of qualified theft through falsification. Since the commission of the first crime merely facilitates or ensures the commission of the second crime, therefore the offender acts only with a single purpose in mind or under one criminal intent. True. Such that there is only one complex crime. Take note. Even if the offender executes various acts to achieve his purpose. So, for as long as there is only one single purpose in mind, or for as long as the offender acted under one criminal impulse or intent, no matter how many acts the offender executes to achieve his goal of committing the second offense, there will be only one complex crime to speak of. For example, X received 5 postal money orders, all placed in one envelope, addressed to Y. Instead of giving these postal money orders to Y, X falsified the signature of the remitter on each of the 5 money orders. So you can observe here that there are already 5 acts of falsification because there is one act of falsification per postal money order. Without the knowledge of Y, X presented them to the post office for encashment on one occasion. So, sinabay niya yung pagpa-encash ng postal money orders. Here, even if there were 5 acts of falsification, X acted with a single purpose in mind. That is to commit the crime of estafa, such that X can only be said to have acted or rather committed one complex crime of estafa through multiple falsifications. So, there were 5 acts of falsifications with the common goal of committing the crime of estafa, acting under a single criminal resolution or intent, such that there should only be one crime committed, that of the complex crime of estafa through multiple falsifications. Okay? Example number 2. But if, in relation to that first example, if X received the 5 postal money orders on different dates, let's say the first postal money order he received today, and then the second postal money order he received 2 days after, and so on and so forth. And then he falsified each of them on separate occasions. Likewise, he presented them for encashment also on different dates or occasions. This time, there will be 5 complex crimes of estafa through falsification. There are 5 complex crimes committed, not just one complex crime, corresponding to the 5 money orders. Can you now see the difference between example 1 and number 2? In example 1, you would notice that he received the postal money orders at around the same time, he falsified them at the same time, and then he encashed them on one occasion. But in example number 2, he received these postal money orders on different dates and encashed them on different occasions. In that sense, he will not be deemed to have acted under a single criminal resolution But there will be as many complex crimes as there are postal money orders in that example. Third requisite, that both or all of the offenses must be punished under the same statute. So we are now into the third requisite. Take note that a felony, this is very important, a felony under the revised penal code should not or cannot be complexed with an offense punished under a special law. Because let's go back to the third requisite. Both offenses or all of the offenses composing this complex crime must be penalized under the same statute, not of different statutes. And this is the rule even if, number one, a single act produces both a felony and an offense. Diba? Compound crime. Or number two, a felony or an offense is a necessary means of committing the other felony or the offense. Again, in order to constitute a complex crime proper, both offenses must be punished under the same statute. For in such a case, the prosecutor can only charge one crime over the other. Let me further explain this through several examples. Example number one, X raped Y, a minor. Here, the single act of rape produces both the felony of rape, punishable by the revised penal code, and it likewise produces the offense of sexual abuse punished under a special law, Republic Act 7610. In such a case, the fiscal, in his discretion, can choose to file a case either for rape or for sexual abuse. He cannot charge both crimes. Okay? He cannot charge both crimes for the same act because doing so will violate X's constitutional right against double jeopardy. Why? Because a person cannot be punished twice for a single criminal act. Okay? Take note of that. Example number two. X raped Y, 11 years old. This time, the crime produced is only the felony of statutory rape because Section 5B of Republic Act 7610 expressly provides that if the victim is below 12 years of age at the time of the commission of the crime, the offender, X in this example, can only be prosecuted for statutory rape under Article 266-A of the Revised Penal Code. In effect, there is only one crime that is produced. Now, you might wonder, hindi ba parehas lang yung example number 1 at saka example number 2 fiscal? The answer is no, because in example number 2, Y here is aged 11 years old, and by express provision of Section 5B of RA 7610, if such be the case, the prosecutor no longer has the discretion either to file a case for sexual abuse or rape. He must file a case for statutory rape under Article 266-A of the Revised Penal Code. So, only one crime is produced here, not two. Example number 3. X, with the use of an unlicensed firearm, killed Y. Here, the offense of illegal possession of firearm, which is penalized by Republic Act 10591, will only be considered as an aggravating circumstance, a special aggravating circumstance to the felony of homicide or murder, as the case may be. So, here, no complex crime is produced. And here, no two crimes is produced also. Only one crime is produced, that of either homicide or murder, and that the use of the unlicensed firearm, which should have been a crime of illegal possession of firearms by itself, will only be considered as an aggravating circumstance. Okay? Example number 4. X was caught in the act of killing Y with the use of a bladed weapon, for which reason he was immediately arrested. Meaning, this contemplates of a scenario where someone caught X in the act of killing Y and X was immediately arrested. No, a warrantless arrest. Now, as a result of the search incidental to his lawful arrest, mean to say he was subjected to search right after he was arrested, he was also caught in possession of an unlicensed firearm. Now, you might ask, how many crimes did X commit here? Since he was also caught in possession of an unlicensed firearm, not to mention he was caught in the act of killing Y using a bladed weapon. The answer is 2 separate crimes are committed here. Homicide or murder on the one hand and illegal possession of firearms on the other. Now you might ask, what is the difference, Mandiay Fiscal, of example number 3 and example number 4? Between rather example 3 and example 4. The difference is the possession of the unlicensed firearm was not used by X in the commission of the crime. Do you see it? In example number 3, X killed Y with the use of an unlicensed firearm. But in example number 4, he was merely caught in possession. He did not use the unlicensed firearm in killing Y. And under Republic Act 10591, if such be the situation obtaining, that will result in a separate charge of illegal possession of firearms. Okay? It will not be used as an aggravating circumstance because it was not used in the first place in the killing of Y. In example number 3, yes, it will be considered as a special aggravating circumstance because it was the means by which X killed Y. But in example number 4, it is considered as a separate offense. So if I were the fiscal, I would file 2 separate charges of homicide or murder and another charge of illegal possession of firearms against X. Example number 5. X, a member of the New People's Army, used an unlicensed M16 rifle when he and his comrades raided a military checkpoint. Here, the use of an unlicensed or loose firearm in furtherance of or in connection with rebellion shall be deemed absorbed as an element of the said crime. No complex crime is thus produced. So this is similar to the commission of common crimes like murder, homicide, robbery, arson in furtherance of the rebellion. Okay? There are other instances where the commission of 2 crimes will not automatically result to a complex crime proper. So what are they? Or what are these? Number 1, a crime to conceal another crime. Example, if a cashier at the city treasurer's office merely resorted to falsification of certain documents to hide the taking of public funds, but this cashier could have malversed the funds just the same even without the falsification, then the falsification and malversation are separate crimes, meaning to say the prosecutor or the fiscal must file 2 crimes or 2 informations against the cashier, one for falsification and another for malversation. Okay? Because The falsification was merely used to hide or to conceal the commission of the other crime. It was not used as a means to commit the second crime or the other crime. A crime, second, a crime which is an element of the other. Okay? This is another instance where the commission of two crimes will not ipso facto result to a complex crime proper. So, for example, the crime of trespassing. There is such a crime as trespassing, like trespass to dwelling or trespass to property. Okay? The crime of trespassing, which is a crime by itself, is an element or happens to be an element in the crime of, let's say, robbery in an inhabited house. If such be the case, then this first crime or this other crime, which is an element of the other, will not be treated as two crimes but only one crime. And presto, it will not result, of course, in a complex crime proper. Last but not the least, a crime which has the same element as the other crime committed. For example, estafa and falsification of a private document have the same element of damage, meaning to say, when you look at the requisites of estafa, in general, damage is an essential element. And in the crime of falsification of a private document, take a look at the underscored portion there, no? Private document. If the offender commits falsification of a private document, damage is also an essential element. If such be the case, since both estafa and falsification of a private document have the same element of damage, this same element of damage cannot give rise to two crimes. It should only be either estafa or falsification. But in contrast, there is a complex crime of estafa through falsification of a public and or a commercial document, because damage is not an essential element when we talk about falsification of a public or even of a commercial document.